Hello everyone. This presentation focuses on principles governing the group liability, joint liability or constructive liability under the Indian Penal Code. When an individual commits a crime, his guilt would be assessed and he would be punished according to the nature of the offense committed, and hence assessing his guilt would not be difficult. When several persons are involved in the commission of a crime and different roles are played by each one of them, how are we to fix their liability? Some of them may be involved in actual commission of the crime, while others may assist in committing the crime or after committing the crime. According to their mode and degree of participation in the commission of crime, they are classified as principals and accessories under English law. Principals are those who are involved in the actual commission of the crime, and accessories are those who assist in the crime before or after the commission of the crime. The Indian Penal Code contains provisions which help in defining the criminal liability of individual members following or forming such groups. These provisions are contained under sections 34 to 38, section 114, section 149, section 396 and section 460. In all these situations, joint liability is created either because the intention is common or the object is common to all the persons forming that group. Sections 34 to 38 deal with common intention. According to section 34, when a criminal act is done by several persons in furtherance of the common intention of all, each one of them is liable for the act as if he alone committed the offense. Section 34 does not create a specific liability but lays down a principle of joint liability or constructive liability. For applying section 34, two conditions have to be satisfied. More than one person must be involved in the commission of an offense, and the offense must have been committed in furtherance, that is, as a consequence of common intention of all the participants. For example, where A, B and C have formed in common intention to cause the death of D. A enters the house with a knife to stab D and stabs D. B stands guard at the entrance to alert A if someone enters the house, and C drives A and B to D's house and after commission of the offense drives them back. Here, A alone had actually committed the act which caused the death of D, but B and C also will be liable for murder as if each one had stabbed D because they were participants in forming an intention or they shared the intention to cause the death of B. Here, A, B and C will be liable for murder of D under section 302 read with section 34. Even if A, who had actually committed the act of stabbing D, is absconding and hence could not be apprehended and prosecuted, B and C can be prosecuted and punished for murder under section 302 by applying the joint liability principle contained under section 34. But where it cannot be shown that there was premeditated concert or prior meeting of minds, the liability cannot be imposed by using the rule under section 34. Now, is it necessary that all the participants should have been physically present at the place of commission of the offense? Physical presence is necessary at the place of offense or in the vicinity of the place of offense to invoke the principle under section 34 if the offense involves physical violence and is such as cannot be committed without being physically present. But where the nature of the offense is such that it can be committed in one place though the accused resides in another, physical presence is not a condition precedent. However, participation is necessary even if it is from different places and at different times. Examples of such offenses are cheating, misappropriation, extortion, etc. Thus, prior meeting of minds and participation by doing some overt act or illegal omission in the crime are essential for imposing joint liability under section 34. Even where 4 persons A, B, C and D have participated in the commission of crime in furtherance of common intention, if all but one, let us say only C, could be apprehended and prosecuted and the rest were absconding, C could be punished for the offence if it can be proved that C was involved in the premeditated concert and commission of crime along with others. If where one of them, say B, was prosecuted along with C for the offence, but his participation could not be proved beyond reasonable doubt and hence acquitted, C could still be punished for the offence so long as it is shown that there was at least one more person along with C who committed the offence by invoking section 34. Section 35 is complementary to section 34. Under this section, when an act is a crime by reason of it being done with a criminal intention or knowledge, everyone who joins in the doing of the act with such intention or knowledge will be liable for the offence as if he had done it all by himself. Under section 34, there is prior meeting of minds of the participants and the act is done in furtherance of the common intention so formed. Whereas under section 35, the person joins the criminal act which already is being done intentionally by one or more persons with the same intention or knowledge. For example, A, B and C are beating X with heavy sticks with an intention to cause grievous injury. D joins them and inflicts blows on X. The effect of all of them was grievous hurt, because of which X was hospitalized for more than a month. Here, D, who joined with similar or same intention, would be liable as if he had all alone caused the grievous hurt of X, along with A, B and C, who were hitting X in pursuance of common intention. In common intention, there is prior meeting of minds of the participants, whereas in same or similar intention, the accused joins in the commission of an offence with the same intention with which the criminal act was initiated by the other or others. Under section 36, when a consequence which is an offence can be brought about by both acts of commission and by acts of omission, a person who brings about the effect partly by acts of commission and partly by acts of omission, he would be liable for the offence. For example, A, with an intention of causing B's death, inflicts blows and omits providing food to him. B dies after 5 days. Here, the beating inflicted may not be sufficient to cause death, and omitting providing food for 5 days may not also be sufficient to cause death. But the joint effect of the act of beating and omitting to provide food was sufficient to cause the death of B, and cause the death of B, the principle contained under section 36 can be applied and A can be held for causing the death of B. According to section 37, when an offence can be committed by several acts of commission or omission, by doing one of such acts or omitting doing one of such acts with an intent to cooperate in the commission of the offence would make the doer liable for the offence. A, B, C and D are jailers, each having to work in shifts for 6 hours. Z was an inmate of the jail. A, B, C and D, with an intent to cause the death of Z, cooperated and omitted to provide food to Z in their respective shifts. Z died of hunger. Here, all the 4 are guilty of murder of Z. Section 38 provides the converse of section 34. Here, where several persons are engaged in a criminal act, they may be held liable for different offences when they do the act with different intention or knowledge. For example, A and B were engaged in a property dispute and had an altercation. When they started exchanging blows, C, who was insulted by A and was waiting for an opportunity to take revenge, approaches A and stabs him with a knife. Here, B will be liable for causing hurt or grievous hurt based on the nature of the injury inflicted by him, but C will be liable for murder of A. Coming to section 114, it says that when an abettor is physically present at the place where the offence abetted is committed, he would be deemed to have committed the offence and hence would be liable for it. Here, abetment means provoking a person or intentionally aiding a person to commit a crime. Section 149 also imposes joint and constructive liability. Here, there is an unlawful assembly, that is, an assembly of 5 or more persons whose object, which is common, is to commit an offence as specified under section 141, and one of the members of this assembly commits an offence in prosecution of the common object of the assembly. All those who are members of such assembly will be liable for that offence. The distinction between the liability under section 34 and section 149 is that under section 34, the liability is for any offence committed in furtherance of common intention of 2 or more persons, whereas under section 149, the accused must have been a member of an unlawful assembly, that is, an assembly of 5 or more persons, for a common object specified in section 141, and the offence must have been committed while prosecuting the common object. In section 34, intention is common, that is, prior meeting of minds is there, whereas under section 149, the intention may not be common, but the accused knows the object of the assembly and joins it, and an offence is committed by some member of the assembly while achieving the object. Where A, B, C, D, E join and with a common intention to threaten X and extort money, start pelting stones at X house. F and G join them and pelt stones. Here, F and G may not be knowing why A and others were throwing stones, but they join the act knowing that the assembly is unlawful. They will be liable for injuring X's property and attempting to extort money under section 149. Now coming to section 396. This is another provision which imposes joint and constructive liability. Here 5 or more persons are involved in committing robbery or are engaged in an attempt to commit robbery. This amounts to dacoity, and while engaged in dacoity, one or more of them commits murder. All those who are engaged in dacoity will be liable for murder, whatever may be his role or contribution in committing dacoity. Supposing A, B, C, D and E attack X's house and threaten the inmates to hand over the valuables. While doing so, A sees that one of the inmates was trying to ring up to the police and immediately fires at him, resulting in his death. Here, all the 5 of them will be liable for murder, though it was only A who actually killed the inmate. This is because the murder was committed while committing dacoity, and hence by virtue of section 396, all those who are participating in dacoity will be liable for murder. Coming to section 460, which also is a provision imposing joint and constructive liability, it states that where during a lurking trespass or housebreaking by night, which is being committed by a group of persons, here more than one person is sufficient, unlike sections 149 and 396 where a minimum of 5 members have to be present. Now, grievous hurt is caused or attempted to be caused. All those who are participating in such lurking trespass or housebreaking by night will be liable for causing or attempting to cause grievous hurt. When a person enters into the house of another without the occupant's consent, and by any means other than through proper entrance, like scaling the pipe, breaking the door or window, etc., during night, that is after sunset and sunrise, in order to commit an offence, it is housebreaking by night. when the unlawful entry is so committed as to hide it from the inhabitants of the house, and this takes place after sunset and before sunrise, it is lurking house trespass by night. When either of these offences are committed by more than one person, and while doing so, grievous hurt is caused or attempted to be caused by one of them, everyone who participated in such trespass would be responsible for it as if he committed the act all alone. Thus, these are some of the rules laid down in the Indian Penal Code to resolve difficulties in fixing liability when more than one persons are involved in the commission of a crime. Thank you.